In the year 1979, the then Prime Minister Shri Morarji Desai appointed the Second Backward Classes Commission under Article 340 of the Constitution. The commission was headed by B.P. Mandal, and its mandate was to investigate the status of socially and educationally backward classes in India. When the commission finally submitted its report in 1980, it recommended a reservation of 27% in government jobs for these castes. Hi everyone, today we will talk about Indra Sawhney case. Supreme Court judgment on Indra Sawhney case forms a very essential part of the polity and governance segment. So we need to talk about it. Before we talk about Indra Sawhney case, we need to talk about affirmative action. What is affirmative action? Affirmative action, which is commonly referred to in India as reservation, was an earnest attempt by the framers of the Constitution to bring in socio-economic equality in Indian society, particularly the reservation in matters of public employment as provided in Article 16 of the Constitution. The framers of the Constitution were aware and conscious of lack of homogeneity of the Indian society. And apart from the differences in religion, culture, language, so on and so forth, there existed people who were in comparison weaker than others economically, socially, and culturally. To improve the conditions of weaker and backward classes and to make them at par with the other sections of the society, the Constitution gave us a mechanism to safeguard the backward classes and scheduled castes. As such, provision for reservation was adopted in the Constitution. Reservation to the socially and economically deprived people as such is not a new concept enshrined in the Indian Constitution, but has been in existence in the pre-constitutional era as well. It is important to mention here that the reservation granted by the former princely state of Mysore on the recommendation of the committee set up in the year of 1918, the demand for some kind of affirmative action has also been taken up before by people like Jyotiba Phule and others, and British did give reservation to some of these classes, but their motives were always of suspectful nature. Over the years, reservation has become more of a political tool than an honest and honest attempt to establish an egalitarian society. A landmark case in the issue of reservation was the judgment that was pronounced in Indra Sawhney versus Union of India and others by the Supreme Court. In the year 1979, the then Prime Minister Shri Morarji Desai appointed the Second Backward Classes Commission under Article 340 of the Constitution. The commission was headed by B.P. Mandal, and its mandate was to investigate the status of socially and educationally backward classes in India. When the commission finally submitted its report in 1980, it recommended a reservation of 27% in government jobs for these castes. The collapse of the Janata Party government complicated matters, and the recommendations of the report could not be implemented. There was not much progress in this respect for several years until Janata Dal regained power in 1989 and decided to implement the recommendation of the report and reserve 27% of seats for socially backward classes. This was followed by reservation and anti-reservation protests in large parts of the country, some of which led to riots. When the government action was challenged before the Supreme Court by way of a writ petition, the then Prime Minister P.V. Narasimha Rao brought in another order which increased the reservation limit to 37% while including economically, socially, and educationally backward classes as well. The 5 bench referred the matter to a 9-judge bench. What were the issues before the court? The court further framed issues, the adjudication of which was essential to deal with the situation at hand, and some of these issues were like whether caste on its own constitute a different class and whether economic criteria could by itself be the detriment of a class. Whether Article 16.4 was an exception to Article 16.1 and is exhaustive in itself of the right of reservation. Does Article 16.4 allow classification of backward classes into backward classes and most backward classes, or permit classification among them based on economic or other consideration? What were the contentions of the petitioner? The advocates for the petitioner, led by Nani Palkiwala, argued that reservation further provoked the evils of the caste system, and this evil will hamper India's march towards being a welfare state. They further argued that if the reservation was continued, it will replace standard with substandard and meritocracy with mediocrity. Petitioners also alleged that the Mandal report was in essence trying to rewrite the constitution. What were the contentions of the respondents? The respondent state said that the report merely gives the backward classes a means to fulfill their just claims. They argued that the report was continuation of the first Minority Commission, which also recommended affirmative action to right the wrongs that backward classes have faced for centuries together. The court, in its judgment, laid down a set of rules which included backward classes under Article 16.4 cannot be identified on the basis of economic criteria, but the caste system needs to be considered. Article 16.4 is not an exception to Clause 1, but an instance of classification as envisaged by Clause 1. Backward classes in Article 16.4 were different from the socially and educationally backward classes mentioned in Article 15.4. The concept of a creamy layer was laid down, and it was directed that such a creamy layer be excluded while identifying backward classes. Article 16.4 does allow the classification of backward classes into backward and more backward classes. Reservation shall not exceed 50%. Moreover, reservation in promotion shall not be allowed. Any new disputes regarding criteria were to be raised in the Supreme Court only. So these were the rules that were laid down in the judgment of Supreme Court. What happened after Indra Sawhney case? A number of developments in the reservation have taken place after the Indra Sawhney case. The Parliament responded by enacting the 77th Amendment to the Constitution by adding Clause 4A to Article 16 in 1995, by virtue of which powers are conferred to the state to reserve seats in favor of SC and ST in promotions in public services if communities are not adequately represented in the public employment. The Supreme Court upheld the validity of Article 16.4A in M. Nagaraj versus Union of India 2006, and it has laid down 3 requirements. Number 1, scheduled caste and scheduled tribe should be socially and educationally backward. Number 2, no adequate representation for scheduled caste and scheduled tribe in public employment. Number 3, it shall not affect the over-efficiency in the administration. A number of state governments enacted the law in consequence of the 77th Amendment of the Constitution. For example, Karnataka extension of consequential seniority to government servants promoted on the basis of reservation to the posts in the civil services of the state 2018 was enacted by the state of Karnataka, and Supreme Court upheld its validity in 2019. Earlier, in B.K. Pavitra case, Karnataka determination of seniority of the government servants promoted on the basis of the Reservation Act 2002 was held to be unconstitutional on the ground that the state had not undertaken to determine inadequacy of the representation, backwardness, and the impact on overall efficiency before passing the law. It is also pertinent to mention here that the Apex Court has also said that there is no fundamental right which inheres in an individual to claim reservation in promotions. In the recent judgment of Mukesh Kumar versus the state of Uttarakhand, which was pronounced in February 2020. If we conclude the Indra Sawhney case, the court in the Indra Sawhney case tried to come up with a solution that is reasonable and strikes a fine balance between the society and rights of backward classes. Removing economic criteria as the sole determinant of classification was also a step in the right direction, as was the exclusion of the creamy layer who had already benefited enough from affirmative action. The court ruling may have been considerate, but subsequent amendments by successive governments to fiddle with the reservation criteria further established the fact that the reservation above all had now well and truly become about vote bank politics more than anything else. In the almost 3 decades after this landmark ruling, the anti-reservation voices have started gathering momentum, but the lawmakers should remind themselves of the duties the framers have given them through the means of the Constitution. The reservation phenomenon has certainly helped in uplifting the backward classes, but there is a long way to go before all historical wrongs are set right. So what was the final judgment of Indra Sawhney case? On 16th November 1992, the Supreme Court in its verdict upheld the government order being of the opinion that caste was an acceptable indicator of backwardness. Therefore, the recommendation of reservation for OBC in central government services was finally implemented in 1992. What was the outcome of the judgment? This judgment also overruled General Manager Southern Railway versus Rangachari and Akhil Bharatiya Shoshit Karamchari Sangh of Railway versus Union of India verdicts, which said that the reservation could be made in promotions as well as appointments. Indra Sawhney versus Union of India held that reservation cannot be applied in promotions. This sums up our discussion on Indra Sawhney case. Thank you so much for watching. If you like watching such kind of content, do not forget to like, share, subscribe and comment. Thank you.